All right, so the Supreme Court has previously held that Title VII does not prohibit race or sex based affirmative action plans in the workplace. Even with the 2023 decision, it doesn't have implications for employment yet. And so that decision was specifically pertaining to affirmative action in education. So it's still relevant to employers and IO psychologists having affirmative action plans in place, to make sure that they are protecting the organization as much as possible from maybe going afoul of the law. So first off, you have to have a written plan. You can't just have like a sense of what your affirmative action goals are. You have to have a written plan. You have to engage in reasonable self-analysis of the relevant employment practice, the hiring or the promotion that is in play here, because affirmative action helps in selection, which is what we've been talking about, right? Because we might want to make sure that we're not discriminating against people while we're selecting, but also has implications for promotion decisions, because a lot of times there'll be, women oftentimes refer to a glass ceiling in an organization where, you can climb pretty decently, but then there's ultimately a hidden and secret level that you're not going to ascend past. Those kinds of promotion decisions, organizations need to be doing reasonable self-analysis to make sure that they are still adhering to the relevant employment practices, that are going to keep them in good legal standing. They need to have a reasonable basis to conclude from the self-analysis that the relevant employment practice has had adverse effect on previously excluded groups or groups whose opportunities have been artificially limited. So you don't want to continue with an affirmative action plan if everything's already been remedied. If we have now gotten rid of whatever historical problems had occurred, we wouldn't want to continue on with this affirmative action plan, because now it just becomes a way to discriminate maybe against the formerly majority group. And so you want to make sure that, yes, that practice that we have gotten rid of still is in play. Like, we still are seeing a deficit. We're still seeing not enough people of different groups. Once it's been achieved, you're supposed to abandon the affirmative action plan. Your affirmative action plan needs to include reasonable action in the plan that is narrowly tailored to solve the problem without placing unnecessary restriction on the workforce as a whole. So your goal is to improve the opportunities that maybe in the past have been discriminated against without interfering with work, without perhaps hiring people who are not as qualified but check a box, or other kinds of things that could be in the long run harmful to everybody in the workplace and to the organization as a whole. We want to make sure that, we get rid of the plan as soon as the plan's objectives have been met. So these are things that are really important to review all the time and make sure that the plan makes sense and that it's adhering to the law. Some major U.S. employment legislation. In 1967, the Age Discrimination Act was, I want to start on the left. 1963, the Equal Pay Act was enacted. And I mentioned this in an earlier video. It's illegal to provide unequal pay and benefits based on sex to people holding equal jobs. So as soon as I say that in a regular class and people could say stuff back to me, I always get somebody saying, but people do it. And it's like, okay, but that's illegal. It's really hard to know what your peers are making. That is a fact. It is very difficult to know what anybody else in your job is earning. And particularly if you perceive yourself to be in a group that might be being paid less, and you ask a member of the group who you think is probably getting paid more, maybe you got hired on the same day, hey, what are you being paid? That's a difficult conversation and very unlikely to occur. So I totally agree with that statement. But it is illegal. And so if evidence is discovered that two people doing the same job are being paid differently and that it seems to be based on their sex, they are in violation of the 1963 Equal Pay Act. In order to pay somebody differently, you have to be able to show that there are sizable and reasonable differences in the work that they're doing in order to justify the unequal pay. And so the organization does have an opportunity to argue back. You might think that I'm paying him more because he's male, but I'm actually paying him more because he's doing something else that you don't know about. They have the opportunity to defend themselves on that. In 1964, like I said before, the Civil Rights Act, Title VII, was passed, and it prohibits employment discrimination based on race, color, religion, sex, or national origin. So they very narrowly specified those things. The EEOC was developed as a result of that, the Equal Employment Opportunity Commission, in order to help enforce this new act. In 1965, there was an executive order that extends the Civil Rights Act to employers holding federal contracts or subcontracts. So the Civil Rights Act initially was not impacting any federal employees. 1991, the Civil Rights Act was reaffirmed and strengthened, and especially for sexual harassment to be added into that, because they said you can't be discriminated. In 1964, they said you can't be discriminated based on sex. They, in 1991, extended sex to mean, and you can't be harassed because of your sex. Some other things that are on here. 1967, the Age Discrimination in Employment Act came along, where you can't fire a person because they're over 40. In 1990, the Americans with Disability Act was brought along, and that requires, we're going to talk about this a little bit more in class later, but that requires employers to accommodate in a reasonable way employees who might have a disability. In 1993, the Family and Medical Leave Act came along. We'll talk about this more in another chapter. And then in 2020, Washington State passed the paid family and medical leave. So we'll talk about that in other chapters. All right, the Civil Rights Act in court, Griggs versus Duke Power in 1971. So this is a very early case. The plaintiff was not hired. He was black and was not hired by Duke Power. And he presented adverse impact data showing that Duke Power wasn't hiring African Americans at least 80% of what they were hiring whites. Duke Power said that it was unintentional. They didn't mean to do that. And they could not demonstrate that the selection battery that they were using to choose employees was based on job-related qualities. And so as a result, Duke Power lost the case, right? Because there was AI. They said, well, it wasn't, we didn't do it on purpose. But then they couldn't point to, we've got good protocols for making sure that we're hiring the best employees that have the skills that we need for the job. And so they lost the case. All right, so the Civil Rights Act distinguished between what we call disparate impact, which is unintentional discrimination against a group, or that is unfairly affecting a minority group. This is where most personnel law cases actually fall, is in the disparate impact. I've heard I pronounced disparate wrong. Apparently it's disparate. I don't know how I spent my entire life calling it disparate, so I'm sorry. If it's grating on your ears, I'm sorry. It's how I've always said it. I must have heard it from a professor somewhere. I don't know where I got that. Anyway, disparate treatment. This is intentional discrimination resulting from differential treatment. Like, this is being done on purpose. So you've got disparate impact, where we're not doing it on purpose, but it is having an impact. Disparate treatment is where it is intentional, and it also has an impact. Bona fide occupational qualification is the criterion that's in the Civil Rights Act that says the employer must show that a particular sex, religion, or national origin is really required or necessary for the job. So you have to show that we have to have men, or we have to have Sikhs, or we have to, right? Like, we have to have people who were born in Italy. Like, we have to have this in order for you can imagine that's going to be all those that I just gave you. Like, those are going to be tough to make an argument with evidence that I must be discriminated, like the job requires that I discriminate. That's going to be a tough act to achieve, right? So when it's intentional, they have to have really good solid evidence for why it's being done. Now, sexual harassment, like I said, it was implied by the Civil Rights Act of 1964. It was solidified in 1991 as part of those protections. I've got this cartoon where she's sitting at her big important desk, and it says formerly the cute blonde in the mailroom, and now she's like vice president or something, right? Quid pro quo harassment. Quid pro quo means this for that. So quid pro quo harassment is where your ability to get promoted or your ability to continue to work for this organization is contingent on you engaging in some kind of sexual behavior with the boss or the president or the CEO of the organization or whatever, people in power are, whoever it is. And it's pretty obvious. Like oftentimes in quid pro quo harassment, it'll be sort of like, now that you're my romantic partner, suddenly you are in charge of the division, that kind of thing. The hostile work environment's a little trickier because it's verbal or physical behavior that creates an intimidating, hostile, or offensive work environment. And a lot of that is in the eye of the receiver, right? Like the person who's being harassed. Interprets it as intimidating or interprets it as hostile or interprets it as offensive. So here we have a cartoon where she has angel wings and she says, just because I wear wings and have a glow about me, don't call me angel. Like that's hostile. That's a put down. Hostile work environments can be a little trickier to establish because the person who's perceiving it as a hostile work environment may have less solid data than a person who's the victim of quid pro quo harassment. I'm going to look ahead real quick. Okay, yeah, sorry. I just wanted to make sure where I was. Okay, so in the quid pro quo harassment, let me give you an example of a real case of quid pro quo harassment. There was a male manager of a store, a Cal Spas store, and his district manager was female. And she was coming on to him all the time and flirting with him all the time. And he was not interested. He was in a relationship and not interested in her advances. And so she invited him to go to a big spa convention. And they were going to stay in the same room. And when they came back, he was going to get promoted to whatever is next after store manager. And he said, no, I don't want to. And he collected all the evidence of these conversations that they'd had and all the things that she'd been saying to him and sued for sexual harassment, quid pro quo sexual harassment. She was clearly wanting him to go stay in the hotel with him and have sex with her. And then she was going to promote him. Like it was a very clear-cut case. But you know what? It was a not as clear-cut case because it was the first case where a man sued for a female sexually harassing him. And so it actually had to escalate and he had to appeal and it went back and forth. And finally, what was determined is that yes, men can be sexually harassed by females. It took longer it took other cases before they were able to establish that men can be sexually harassed by other men. So in that case, he was able to provide documentation that she was making these offers and she was making these promises to him. With hostile work environment, it can be a little trickier because it might be, for example, there was a case where the female front desk person at a car repair shop of some sort said that it was a hostile work environment because when she needed to, say, bring a phone message to somebody back in the shop, first off, there were posters and calendars with scantily clad women on them that made her feel bad. And then when she would go to the back, the mechanics would tease her, make off-color comments to her, these kinds of things that really was drawing attention to the fact that she was female in a group of males and they were all sort of sexualizing her. And she felt like the posters were sexualizing her and making her feel bad. And that one was another one that was a difficult case because it was all sort of like how she was being made to feel versus what they claimed they meant. And so kind of different, the two different perspectives. And so ultimately it was decided that what the men were engaging in was in fact sexual harassment. It was a hostile work environment, and that they were doing it on purpose to make her feel bad. And so that, these are tough cases, right, to establish. All I can say, if you're ever in a situation that you believe is a hostile work environment, document every single instance, like write it down from the first time it makes you feel bad, and document that you have told people who are in charge about it. Like tell the manager, tell somebody that this happened and it made me feel uncomfortable. I would like you to speak to that employee about this. And if they refuse to do it, then with your documentation, you can go to the EEOC's website, and within 6 months of the most recent harassment, so like the last date of on your records, within 6 months, you can file a grievance with the EEOC. And if you can document, I told, my manager, and my manager told me that I need to just get over it. And then I told the manager above them, and they said, well, you have to go through the chain of command. Have you talked to this other person? Well, if that's what he said, then that's what we're going with. Like, you have to document all that. And then the EEOC can go after the employer for not having done anything about the harassment they were on notice about. If they don't know about it, they're not responsible for it. So you have to tell them. That's my piece of advice with regard to sexual harassment, whether it's quid pro quo or it's hostile work environment. But a lot of times it's hostile work environment, and people will think, well, I'll just not laugh when they tell those jokes, or I'll just try to avoid them, or I'll just not look at them and it'll go away. And A, it typically doesn't go away. B, it tends to escalate. And C, you need to document all these things and actually say something to someone. You may not feel comfortable talking to your harasser, but you should be able to talk to the person who's above the harasser and tell them, I'm not going to say anything because I think it's only going to make it worse. So I need you to talk to them about it. And I'll just give you an example. I was a 22-year-old working in the mortgage lending division of a large bank, and the appraiser, who was male, and the VIP loan officer, who was male, were like the only males on the floor. And their two cubicles were directly adjacent to my little workstation where I was typing. And they would tell me jokes and tease me and say all sorts of off-color things about I won't get vivid about it, but just like very not appropriate stuff. And I tried to just ignore them. I was always taught to ignore them. I'm a good psychology major. Skinner says to ignore stuff. I tried to ignore them, but they would escalate. They'd be like, did you hear us? Did you hear what I said? Why aren't you laughing? You look better when you smile. Those kinds of things. And then I told them, you know what? Stop teasing me. I don't think any of this is funny. And they're like, oh, you can't take it. You don't think it's funny. So I'm like, okay, this is obviously not working. And so I marched into my supervisor's office, which I luckily had a very strong female supervisor, who she immediately marches out and tells those guys, knock it off, stop talking to her. And they never spoke to me again. They were like, well, first they pouted about it and acted like, now they're mad at me because I did something wrong. And I was like, I don't care. Just stop telling me those stupid jokes. But I didn't expect her to march out there and embarrass me right then. But on the other hand, they stopped talking to me, so it worked out. So that's like the kind of thing that you kind of have to do. And if she had not marched out there, I needed to write that down. And then I needed to go to her supervisor. And if he did nothing about it, then I would have needed to have filed something with the EEOC. But guess what? This was pre-1991. So I don't know how seriously they would have taken it. So yeah, times have changed, luckily. But that's my role modeling for anyone who's ever been the source or the target of any kind of harassment. You have to speak up. So, all right, I'm going to stop here, and then we are going to wrap up this chapter in the next video.